Chapter 3: The Role of the Attorney in Child Support Enforcement. Introduction. A lawyer is a legal representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. As a representative of clients, a lawyer performs various functions. As advisor, a lawyer provides a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. As advocate, a lawyer zealously asserts the client's position under the rules of the adversary system. As negotiator, a lawyer seeks a result advantageous to the client, but consistent with the requirements of honest dealing with others. As intermediary between clients, a lawyer seeks to reconcile their divergent interests as an advisor and, to a limited extent, as a spokesman for each client. A lawyer acts as evaluator by examining a client's legal affairs and reporting about them to the client or to others. Above are the first two paragraphs of the preamble to the American Bar Association's Model Rules of Professional Conduct, final draft, herein called Model Rules. The quotation effectively categorizes the functions, or roles, that an attorney performs as part of his or her profession. All of the roles mentioned above have relevance to attorneys employed by the Child Support Enforcement Program to represent the interests of the state and of custodial parents and their children. The attorney as advisor. The extent to which a child support enforcement attorney performs the role of advisor will vary from one jurisdiction to the next and will depend on the amount of contact the attorney has with the 4D agency. Attorneys employed directly by the agency are often in the policy-making loop and are actively involved in the program in an advisory capacity. Attorneys who serve the program on a contract basis, or who are tied to the program by statute, such as prosecuting or district attorneys, may be less involved in providing legal advice to program administrators. The latter group often advise program administrators by serving on ad hoc advisory committees or by providing day-to-day feedback on specific cases. In many instances, the attorney will be in a position to give legal advice to custodial parents in the process of working a case. The attorney as investigator. While the child support enforcement attorney typically has a wealth of investigative support upon which to draw, some investigative functions can be performed only by an attorney. Once an action is pending, the attorney has discovery devices and subpoena power, investigative tools generally not available to administrative personnel. In addition, the attorney often can obtain information from private, outside sources, such as employers, by citing legal authority as the basis for the request and by lending to the effort an added degree of credibility. Attorneys routinely perform other investigative functions that may be carried out most effectively and efficiently by the attorney in conjunction with other activities. For instance, in preparing to take a contested paternity case to trial, the attorney often conducts a more detailed interview with the mother and other witnesses. The attorney as negotiator. Because the program lacks sufficient resources or available court time to take a significant percentage of child support cases to court, the child support enforcement attorney must be adept at negotiating contested situations into workable resolutions. The attorney commonly serves as intermediary between or among the separate governmental agencies which must work together to make the program effective and efficient. These functions often require a delicate balance between the interests of the 4D program and the people with whom the program comes into contact. The ethical problems associated with negotiation are perhaps the most serious and difficult to resolve of any the child support attorney faces. The attorney as advocate. As advocate, the attorney is the legal representative of the 4D agency, the state, and, indirectly, the custodial relative and the child. The attorney must be keenly aware of all relevant statutory and case law which exist in the jurisdiction. The attorney must analyze facts to determine the most effective and appropriate course of action or remedy for each case, and then carry out the necessary legal steps to bring the power of the court to bear on the problem. As advocate, the attorney has a duty to afford the 4D agency the opportunity to appeal cases which are decided in error and, perhaps, thereby create new law. The attorney as officer of the court. As an officer of the court, the attorney has a responsibility to protect the court from abuse of its processes, to take an active role in educating the judiciary regarding the law and public policy that should be applied to child support cases, and to be constantly seeking innovative ways to improve the legal system in the jurisdiction. The attorney as public official. As noted above in the preamble to the model rules, all attorneys have a special responsibility of citizenship, based on their proximity to the legal system and their special training, to foster the quality of justice. This responsibility applies to government attorneys with additional weight because of their direct involvement in the administration of the government program. The child support attorney has a responsibility to the legislature to assure the goals of the program are carried out, and a duty to the public at large to protect the rights of individual citizens. This chapter will discuss each of these roles and apply the ethical standards contained in the new model rules to common fact situations and ethical dilemmas faced by the child support enforcement attorney. The model rules inform the chapter because the bar's own ethical considerations are the most authoritative guide to the attorneys in fulfilling their function on behalf of clients. Who is the client? The most fundamental issue for consideration is who is the client. As many writers in the field of legal ethics have pointed out, this issue may appear simple but can be very difficult for attorneys who work for large organizations or government agencies. The typical corporate or government attorney always deals with the corporation or agency through an intermediary, that is, a human being. It is not always clear to the attorney whether the client is the intermediary, some subdivision of the organization as a whole, the entire organization, its top management, or even the constituents whom the management represents, shareholders or taxpayers. Conflicts can arise among the interests of these various potential clients which put the attorney in a very uncomfortable position. The child support enforcement attorney faces an additional layer of uncertainty due to the presence of another individual, the custodial relative. The question naturally arises as to whether an attorney-client relationship exists between the attorney and the custodial relative. If so, many ethical considerations would affect the way the 4D attorney conducts negotiations, makes tactical decisions as to which remedies or causes of action should be pursued, maintains client confidences, and resolves conflicts between the interest of the custodial relative and the state. In the first decade of the child support enforcement program, courts and bar ethics tribunals only rarely dealt with the issue of client identification. However, more recently, judges have considered the issue as absent parents attempted to avoid collection actions by challenging the state's involvement in the program. The argument can be made in a number of ways, but the most popular involves equal protection. This argument posits that by providing legal counsel for custodial parents but not for absent parents, the state violates the absent parent's right to equal protection. The same argument can be based on state constitutional provisions prohibiting legislatures from spending public monies to effect private purposes. Both of these arguments have failed. See Florida Department of Health and Resources v. Heffler, 382 So 2D 301, Fla. 1980, State Ex Rel. Leet v. Leet, 624 SW 2D21, Mo. 1981, Johnson v. Johnson, 634 P2D 877, Wash. 1981. In these cases, the courts found no constitutional violation because the states involved were not motivated by a purpose to provide legal services to the custodial parents. Federal and state statutes created the Child Support Enforcement Program to further the compelling public interest in safeguarding the child's constitutional rights, protecting the taxpayers, and assuring that the primary obligation for child support falls on the parents. Johnson, Supra, p. 881, viewed in this light, the attorney's function in all 4D cases is to further those public interests, not to represent the narrower interests of individual custodial parents. A number of bar ethics committees have taken up the issue in response to questions from members of the bar. The questions generally refer to the conflict of interest that arises from time to time when a 4D attorney becomes aware that a custodial parent who is receiving AFDC was ineligible for a period of time. Bar ethics opinions from the states of Oregon, Missouri, and Tennessee 3 have held that the attorney in a 4D case represents the state and not the support obligee. Therefore, there is no impropriety in informing the proper authorities concerning welfare fraud. Likewise, A 1967 opinion of the North Carolina Bar Ethics Committee held that no attorney-client relationship existed between the public prosecutor and a custodial parent receiving support enforcement services pursuant to a program established prior to the passage of Title IV.D of the Social Security Act. 47. Similarly, in Gibson v. Johnson, 35 App. 493, 582 P2D 452, 1978, the Oregon Court of Appeals held that no attorney-client relationship exists between the child support enforcement attorney and the AFDC recipient. In Gibson, a class action was brought on behalf of all AFDC recipients, seeking the entry of a mandatory injunction. The injunction would have enjoined attorneys from the Oregon Department of Justice from representing AFDC recipients in child support proceedings without first conforming to the disciplinary rule that requires the lawyer to decline multiple representations unless he or she can represent each client adequately without conflict of interest and make full disclosure of any potential conflict. The trial court found the rule applicable and entered an injunction. On appeal, the court held that the relationship between the AFDC recipient and the state is one of assignor-assignee, not attorney-client. The involuntary nature of the relationship, and the fact that the state is collecting support principally to offset the costs of AFDC, were the deciding factors, despite statutory language which spoke of representation of the child, or children, caretaker parent, other dependent person, or the Department of Human Resources. CORS 23.789, 2. The issue surfaces in one other context in a remarkable opinion from New York State. There, the Bar Ethics Committee held that it was not an ethical violation for the alleged father's attorney in a pending paternity case to contact the AFDC recipient mother directly, that is, without notifying the relevant public attorney, in an attempt to obtain a statement to exonerate his client. Again, the rationale was that the absence of an attorney-client relationship between the AFDC recipient and the public attorney prevented application of normal ethical standards. Had the relationship been held to exist, the alleged father's attorney would have been prohibited from contacting the AFDC recipient except through the public attorney. The authorities on this issue agree that the only attorney-client relationship arising in the normal IV.D context exists between the attorney and the agency for whom he or she works. Unfortunately, the decisions cited above contain little analysis to allow the reader to decide on their merits. Moreover, all of the decisions and opinions which are directly on point involve AFDC cases, with no criteria for extending their applicability to other facts situations. As a general rule, the client is the party with whom the attorney has the longest-term professional relationship, the party who initiates or monitors that relationship, or perhaps the party to whom the attorney looks to get paid. One other measure would involve policy-making authority granted by the legislature. Normally, the client retains the authority to decide whether or not to pursue a legal remedy, after the attorney provides the client with an opinion. If the legislature has vested an executive agency with the authority to administer the IV.D program, and therefore to decide which cases are referred to the attorney for legal action, then the executive agency would be performing the traditional client function. If, on the other hand, the legislature has delegated the function of administering the program directly to the county, district, or state's attorney, then the client might be that individual or office, to the same extent as in criminal prosecution cases. In either case, the custodial parent, to a large extent, has been divested of control over whether or not an enforcement or establishment action will be taken. While this is less true for non-AFDC cases, the IV.D agency, or the local public attorney acting in the role of the IV.D agency, still initiates the relationship between the custodial parent and the attorney, and controls the priority to be granted the case. In both situations, the agency decides whether legal resources will be brought to bear on a case and how much will be spent on each case. Again, the agency seems to be functioning in the role of the client. Specific ethical problems. Competence. Model Rule 1.1 requires the lawyer to provide competent representation to his or her client. Competent representation is defined as the legal knowledge, skill, thoroughness and preparation reasonably necessary for the representation. In the comment to the rule, ABA's Commission on Evaluation of Professional Standards states that competent handling of a particular matter includes inquiry into and analysis of the factual and legal elements of the problem, and use of methods and procedures meeting the standards of competent practitioners. It also requires adequate preparation. This level of competence in the child support enforcement field requires a diverse amount of knowledge and several different skills. The attorney must be fully aware of the substantive and procedural issues which may arise as a case is worked, and how to apply his or her jurisdiction's case law, court rules, and statutes to resolve such issues in the client's interest. In addition, the attorney absolutely must be aware of federal statutes and regulations which affect the implementation and administration of the 4D program in his or her state. Included in the list of relevant sources are the following: federal and state constitutions, Social Security Act, 42 U.S.C. 601 et sec. 45 CFR 399 Bankruptcy Code, 11 U.S.C. 362, 522, 523A, 5A, Internal Revenue Code, 26 U.S.C. 6305 and 6402C, Soldiers and Sailors Civil Relief Act, 50 U.S.C. Appendix 520, Federal Consumer Credit Protection Act, 15 U.S.C. 1671 to 1675, 1681 net. Sec. State Dissolution of Marriage Statute, Uniform Reciprocal Enforcement of Support Act, Uniform Child Custody Jurisdiction Act, State 4. De-implementing legislation, state creditors' remedies, state exemption statutes, state probate law and procedure, applicable statutes of limitation and dormancy and revival statutes. In addition to acquiring a thorough knowledge of the above, the 4D attorney must understand the underlying purpose of each and their connections to the goals of the child support enforcement effort. For the most part, the enforcement of child support obligations is consistent with the public policy behind these other enactments. When two areas of public policy collide, the attorney must apply sound legal reasoning to help the executive or judicial branches resolve the conflict. Such thorough knowledge develops only with the study of the case law which construe the statutes. With regard to the federal statutes and regulations and the Uniform Acts, it is necessary to study the case law from all jurisdictions in the country. The most important skills that must be developed involve interviewing, negotiation, and trial practice. Negotiation is such an integral part of the lawyer's role that it is recognized as an area in which the attorney must exhibit a high degree of competence. See 42 text.b.j. 439, 1979. Clearly, this is particularly true for the child support enforcement attorney who must process a large caseload in an efficient manner. Paternity cases, in particular, test the attorney's trial practice skills. To comply with Rule 1.1, all child support enforcement attorneys must develop knowledge and skill in trial practice and in the scientific basis of genetic paternity testing. Once the requisite knowledge and skills are obtained, the attorney must apply them to individual cases. This requires devoting adequate preparation time to cases prior to taking action. Finding time to prepare can be challenging when caseloads are high, as is often the case. Nevertheless, the child support enforcement attorney has an ethical obligation to bring competent representation to each case. The model rules make no exceptions for heavy caseloads. Scope of representation. Model Rule 1.2 emphasizes that the client has the ultimate authority to determine the purposes to be served by legal representation, within the limits imposed by law and the lawyer's professional obligations. Model Rule 1.13 states that a lawyer employed or retained to represent an organization represents the organization as distinct from its directors, officers, employees, members, shareholders, or other constituents. Most state legislatures have delegated the policy-making functions in the 4D program to the Social Services or Revenue Agency. Thus, one can argue that the child support attorney should yield to the decision-making authority of program management, except where a decision requiring legal expertise is involved or where the management clearly is acting outside the limits imposed by law. The Commission's comment further points out that the attorney should assume responsibility for technical and legal tactical issues, but should defer to the client regarding such issues as the expense to be incurred and concern for third persons who might be adversely affected. Certainly, this last clause applies with less force to the government attorney, who must act as a minister of justice in addition to more traditional roles. Nevertheless, the ethical consideration has significant ramifications for the child support enforcement attorney. A good discussion of the proper relationship between government counsel and the agency he or she represents may be found in Dean Redlich's Professional Responsibility of the Lawyer in Government Service. In this article, Dean Redlich uses the facts of the famous case of Marbury v. Madison, 5 U.S. 1 Crunch, 137, 1803, to analyze the role of the attorney in advising the government client. The facts in Marbury do not translate sufficiently to the 4D attorney's situation, so the discussion here adapts Redlich's analysis to a more familiar situation. Redlich encourages the government attorney to decide whether he or she is a hired gun or a policy maker, and concludes that the proper role falls somewhere in between. He labels this role gatekeeper. As gatekeeper, the attorney allows the policy makers to set policy, but encourages them to apply the legal advice which he or she is competent to provide. Once policy is set, the attorney interferes in its implementation only where it infringes on his or her right to state a professional opinion, or where implementation clearly would violate the constitutional rights of affected third parties. Examples provide a clearer understanding of this concept. Assume that the state legislature enacts a state income tax refund interception statute that provides that any liquidated debt, whether or not reduced to judgment, may be collected through set-off. Assume further that a state or local administrator asks the attorney to research and determine whether the statute may be used to collect unreimbursed AFDC from absent parents against whom no support order has been established. The attorney conducts extensive research and concludes that the absent parent's obligation to reimburse the state for AFDC paid to his family does not constitute a liquidated debt and that the statute cannot be used for such a purpose. Lastly, assume that before the attorney can issue an opinion, the administrator informs the attorney that his or her opinion must be that the statute may be used. Redlich says that the attorney in such a situation should stand by his or her professional opinion and refuse to issue the opinion mandated by the administrator. Here, the client, through its representative, has attempted to infringe on the attorney's professional opinion. According to Rule 1.1, the attorney should exercise his or her independent judgment. The rule is more difficult to apply, and the example a bit more credible, if the facts are slightly different. Assume this time that the 4D director allows the attorney to state his opinion. Instead of arguing or trying to dictate the attorney's professional opinion, the administrator simply says, "Fine, I respect your opinion, but this issue is very important to the program in this state. Too important to allow a single opinion to control the way in which we implement the debt set-off mechanism. I want you to draft a request for an Attorney General's opinion in which you put forward the best legal argument you can devise for extension of the mechanism to the non-court-ordered caseload." Redlich concludes that, in this situation, the attorney should comply with the request. He notes that, for the purposes of this situation, the agency alone is the client, and the attorney is the only source of legal expertise available to the agency. Since refusal to draft the request effectively denies the agency the use of the remedy, the attorney has a duty to comply. Now assume that after the administrator asks for the attorney's opinion, he simply states that the 4D agency intends to implement the debt set-off mechanism on cases where there is no court order, despite the attorney's opinion that to do so would violate absent parents' due process rights. This is a particularly difficult situation for many attorneys in government service. As a general rule, a client should be allowed to ignore his or her attorney's opinion, even when to do so would be clear folly. This principle applies to the government attorney-client context with almost the same force as in the wholly private context, with one important exception. The government attorney is also a public official, with a responsibility to the public at large and a professional obligation to the agency paramount to his or her responsibility to any individual administrator. Model Rule 1.13 specifies a number of appropriate responses for the attorney who knows that an individual in the organization is intending to enter into action that violates the law and is likely to result in substantial injury to the organization. The attorney can make internal requests for review, except where the organization's highest authority insists upon taking action which is clearly illegal. At that point, the lawyer may reveal information to higher governmental officials. It is noteworthy that the list of appropriate responses does not include a refusal to provide legal services to the administrator in defense of his or her action, where the attorney believes that his or her participation in the action would be itself unethical. The attorney's only alternative would appear to be resignation. Communication. Model Rule 1.4a states that a lawyer shall keep a client reasonably informed about the status of a matter and promptly comply with reasonable requests for information. Subsection b requires the attorney to explain any such matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Most attorneys serve the child support enforcement community through cooperative agreement with the state or county 4D agency. The 4D agency typically investigates the facts in a case and refers the matter to the attorney if legal action is appropriate. In states where the Attorney General's office is the 4D agency, the referral will be an in-house procedure, but otherwise identical. Either way, a case file may be in the possession of an attorney, and out of the possession of agency personnel, for weeks or months at a time. Rule 1.4 clearly requires that the attorney and the 4D agency maintain some level of communication. The attorney need not communicate with the agency to the same extent as with a private client. Nevertheless, the attorney must defer to the agency regarding the purposes to be served by the representation, thus allowing the agency to assume the role allotted to the client by Rule 1.2. Scope of representation. The agency and the attorney should agree on the extent of communication regarding each specific case and resolve the matter in the cooperative agreement. It must be clearly established what information is to be communicated by the attorney to the agency, at what intervals, and in what form. Confidentiality. Generally, a lawyer is prohibited from disclosing information relating to the representation of a client except where the client consents after consultation. In addition to stating the general rule, Model Rule 1.6 establishes exceptions if the lawyer reasonably believes disclosure is necessary to prevent the client from committing a criminal act which is likely to result in imminent death or serious bodily injury, or whether disclosure is necessary to establish a claim or defense on behalf of the lawyer in a dispute between the attorney and the client. The second portion of Rule 1.6 is rarely relevant in a child support enforcement case, regardless of the correct identity of the client. Nevertheless, subsection A of the rule apply in at least 3 situations: when it becomes apparent to the child support enforcement attorney that an AFDC recipient, or former AFDC recipient, has committed some form of welfare fraud during the period in which he or she received AFDC, when an absent parent or his or her attorney seeks to discover the location of the custodial parent, usually in order to visit the children, in response to child support enforcement activity, when an employee of the child support enforcement agency takes action, or threatens to take action, on a case which will violate the rights of an absent parent. The fraud situation has produced quite a number of bar ethics opinions as program attorneys have sought to define the extent of the attorney-client relationship which might exist between themselves and custodial parents or relatives. As noted above, the verdict has been unanimous. The child support enforcement attorney has no duty to protect the AFDC recipient, child support obligee from disclosure to the welfare agency of facts that would call present or past eligibility into question. Bar ethics opinions from Nebraska, NEB. Opus 7615, the 12th of October 1976, Missouri, Inf.Op. Number 15, the 28th of June 1979, Oregon, Op. Number 322, 676, and Tennessee, formal Opus 83, F-55, have all held that such situations present no confidentiality or conflict of interest problems. Moreover, The Missouri and Tennessee opinions hold that the prosecuting attorney not only may disclose the information to the Social Services Agency, but also bring criminal charges against the AFDC recipient for fraud. The Oregon opinion, at p.2, adds the caveat that the attorney should inform the AFDC recipient that he or she does not represent the AFDC recipient for any purpose, and that the recipient may wish to consult with a private attorney or an attorney from a legal aid society. Unfortunately, all of the cited opinions concern AFDC cases where the family is no longer receiving AFDC. The relationship between the attorney and the custodial relative is more like that of a private attorney and client. The attorney represents the interests of the family, and the interest of the state is less direct. One might conclude that a different confidentiality rule would apply for non-AFDC cases. Two arguments mitigate against such a conclusion. First, the Missouri and Washington cases cited above, Leet and Johnson, respectively, supra, propose that even in the non-AFDC situation, the state's involvement in child support enforcement furthers the public interest at large, and is not principally intended to benefit the custodial relative. Second, the statutory basis of the non-AFDC portion of the 4D program, 42 U.S.C. 654-6, prescribes that the state provide the same services in non-AFDC cases as in AFDC cases. If the level of service is defined by that provided in AFDC cases, any conclusion that a more extensive relationship exists in non-AFDC cases is hard to justify. If the conclusions in the above paragraph are valid, then no confidentiality restrictions would arise out of the relationship between the child support enforcement attorney and the custodial parent. Even if the attorney learns of facts that suggest that the non-AFDC applicant committed welfare fraud during an earlier period, there would appear to be no problem with reporting that fact to the welfare agency. Again, the attorney should discuss the absence of the attorney-client relationship with the non-AFDC applicant at the outset of his or her involvement in the case. The second situation listed at the outset of this discussion is a bit more difficult to resolve. Absent parents and their attorneys frequently seek to discover the whereabouts of the children in response to child support enforcement activity. Again, if we assume that no attorney-client relationship exists, there is no ethical rule which prevents disclosure of this information. However, provisions in state and federal law limit disclosure of information regarding recipients of support enforcement services. Federal Regulation 45 CFR 303.21 provides as follows. A. Under state statute which imposes legal sanctions, the use or disclosure of information concerning applicants or recipients of support enforcement services is limited to purposes directly connected with 1. The administration of the plan or program approved under Parts A, B, C, or D of Title IV or under Titles 2, X, 14, 16, 19, or 20 or the Supplemental Security Income Program established under Title 16, 2, any investigations, prosecution or criminal law proceeding conducted in connection with administration of any such plan or program, and 3. The administration of any other federal or federally assisted program which provides assistance, in cash or in kind, or services, directly to individuals on the basis of need. B. These safeguards shall also prohibit disclosure to any committee or legislative body, federal, state, or local, of any information that identifies by name or address any such applicant or recipient. It is important to note that 45 CFR 303.21 establishes a general rule of non-disclosure of any information which identifies a recipient by name or address. For a proper disclosure, one of the exceptions must apply. Subdivision 2 of subsection A would seem to apply to the situation posed above. Under this exception, any information which must be disclosed in order to litigate the child support or paternity action would seem to be disclosable. Because this is an exception to a general rule of non-disclosure, it is wise to refer requesting absent parents to the court file, which will often provide the information sought. It is best to refuse to disclose additional information, on the basis of regulation and state statute, unless ordered by the court to release the information. The third and final situation posed above involves the attorney who learns that an agency employee intends to or already has, violated law or agency policy in attempting to collect support. If the attorney assumes that an attorney-client relationship exists between the child support enforcement attorney and the child support worker, then a potential confidentiality problem exists. Such an assumption would prove incorrect. Rule 1.13 reminds the attorney that his or her relationship is with the agency as a whole, not with any of its individual employees or officers. The attorney's relationship with the agency should prevent disclosures to outside parties, but there is no ethical prohibition against the attorney disclosing the matter using proper agency channels. Recipients of child support enforcement services, child support workers and, more importantly, child support administrators should be aware that no attorney-client relationship exists, and that a child support attorney's paramount duty is always to the agency. Conflicts of interest. The Model Code deals with conflict of interest problems in 3 separate rules. Rule 1.7 states, inter alia, that an attorney should not represent a client if representation of that client will be directly adverse to a current client, or if the attorney's existing responsibilities to the current client will affect adversely the representation of the prospective client. The latter requirement limits the attorney from representing a prospective client if the attorney has interfering responsibilities to a third person, or if the attorney has conflicting personal interests. Rule 1.8 lists prohibited transactions and restates the confidentiality rule discussed above. A subsection of Rule 1.8 prohibits an attorney from accepting compensation from a third party on behalf of a client, unless the client consents after consultation and the third-party judgment does not interfere with the attorney's independence of professional judgment or the attorney-client relationship. Rule 1.9 prohibits an attorney who has represented one client from thereafter representing another client in the same or in a substantially related matter in which the second client's interests are materially adverse to the interests of the former client, unless the former client consents after consultation. The rule further states that information relating to representation of the first client cannot be used to that client's disadvantage, except as allowed by Rule 1.6, or where the information has become general knowledge. These 3 conflict of interest rules are relevant to child support enforcement attorneys in at least 2 important contexts. The first is where the attorney has represented one of the parties regarding the support obligation in his or her capacity as private attorney. This can be troublesome for child support enforcement attorneys who were formerly in private practice or who are allowed to maintain a private practice in addition to their child support enforcement responsibilities. The combination of these 3 rules would seem to disallow the attorney from representing the 4D agency in a child support case in which he or she was involved as private counsel, except where the former private client consents after consultation. If the former client is the support obligee, he or she may consent. However, the attorney should explain his or her new relationship to the 4D agency as part of the consultation required by the rules. Where the former private client is the support obligor, the attorney no doubt will have to ask the 4D agency to refer the case to another attorney. In order to avoid this particular ethical dilemma, child support enforcement attorneys who also have private practices should avoid divorce and paternity cases in their private practices. The second potential conflict of interest occurs when the child support enforcement attorney conducts his or her relationship with the custodial parent as though a formal attorney-client relationship exists, and the interests of 4D agency conflict with the interests of the custodial parent. Because the problem arises differently depending on whether or not the custodial parent is receiving AFDC benefits, the following discussion is divided into AFDC and non-AFDC components. AFDC cases. To define the potential conflict of interest, it is necessary first to discuss the nature of the relationship between the 4D agency and the AFDC recipient. A custodial parent who applies for and receives public assistance must assign his or her support rights, including accrued arrearages, to the 4D agency, or the state. 45 CFR 232.11. The state becomes vested with legal title to the entire amount of outstanding arrearages. Should a collection be made, the 4D agency first distributes $50 of current support to the family. Next, it compares the amount of current support ordered by the court, or administrative agency, if applicable, to the AFDC grant amount for the month in which the collection is made. If the amount of the order exceeds the amount of the grant, and the collection exceeds both, the 4D agency must distribute the difference between the grant amount and the order to the family. The 4D agency may retain the remainder of the collection up to the total amount of AFDC paid out to the recipient for any prior period. Any amount that exceeds the total amount of AFDC paid out to the family in prior periods must be distributed to the family. 45 CFR 302.51. Thus, it might be argued that the AFDC recipient retains a limited equitable interest in the arrearage, even after having assigned it to the 4D agency. The difficult ethical dilemma, and possible conflict of interest, occurs when a large arrearage is involved, and the absent parent offers the child support enforcement attorney a settlement that would compromise some of the arrearage. The problem is best understood by way of example. Assume that, at the point in time when a family applies for and receives AFDC benefits of $200 per month, an outstanding arrearage exists in the amount of $4,400, on a current support obligation that calls for monthly payments of $100. Assume further that it takes 4 months for the case to be referred to the child support enforcement attorney, so that the support owed now has reached $4,800. During this 4-month period, the family has been paid $800 in AFDC benefits. Applying the above federal regulations to this set of facts and assuming that $4,800 is collected, the collection would be distributed as follows. $50 of the current monthly support collection directly to the family, the remainder of the current collection, $50, to offset the current monthly assistance payment. $600 to the state. $4,100 to the family. The ethical problem arises when the attorney receives an offer of compromise in any amount that is less than the outstanding arrearage. The 4D agency might be very willing to accept a $2,000 settlement to dispose of the case. Whether the state collects $2,000 or $4,800, it will retain the $650 to which it is entitled under the federal regulations. If the only true attorney-client relationship is the one that exists between the attorney and the 4D agency, the attorney has no true conflict of interest and may accept the offer of compromise after communicating it to the 4D agency and obtaining consent from an individual who possesses authority in such matters. If the attorney believes that a true attorney-client relationship exists between himself or herself and the AFDC recipient, a conflict of interest arises unless the recipient is informed of the settlement offer and consents. Because all of the arrearages forgiven cost the recipient and not the state, consent may be unlikely. Determining that no such relationship exists and communicating that fact to the AFDC recipient at the outset may resolve the potential conflict. Unfortunately, such a precaution does not make the attorney's negotiations with the absent parent any easier or less uncertain. Clearly, the absent parent should be fully informed of the limited scope of the attorney's representation, and that the settlement may not bind the recipient. Non-AFDC cases. Using the same set of facts as above, a potential conflict can be constructed between the duty owed by the attorney to the 4D agency and that owed to the custodial parent in a non-AFDC case. Assume that all facts are the same except that the family ceases receiving AFDC at the end of 4 months, and, instead of settlement in the amount of $2,000, the absent parent offers to pay current support plus the entire arrearage back in increments of $100 per month as part of an income assignment arranged through the absent parent's employer. Assume that the 4D agency's policy is to accept and promote such arrangements and to keep the arrearage payments until the state's share is paid in full. In this case, the custodial parent would not receive any of the arrearage money for the first 8 months the income assignment is in effect. If the custodial parent objects to this arrangement, the conflict of interest arises. The 4D agency may wish to accept the settlement, whereas the custodial parent may want the attorney to pursue other available remedies. Again, the attorney may be able to avoid the conflict by concluding that the only attorney-client relationship exists between himself or herself and the 4D agency, and so informing the custodial parent. Any other conclusion forces the attorney to sublimate the interests of one client to the interests of the other. Maintaining independent professional judgment. Rule 2.1 requires an attorney to exercise independent professional judgment and render candid advice to a client. It also encourages the attorney to supplement purely legal advice with reference to relevant non-legal considerations such as moral, economic, social, and political factors. The maintenance of truly independent professional judgment can be difficult for the prosecuting or district attorney who has local constituents to please in addition to the child support enforcement responsibilities prescribed by statute, cooperative or agreement. This ethical rule reminds us that the interests of the 4D agency or the families and taxpayers it represents must not suffer because of local political or commercial interests. For instance, local employers may resist compliance with income withholding orders due to the cost and inconvenience involved in deducting support payments from the paychecks of their employees. The influence of such local employers should not affect the prosecuting or district attorney's willingness to use income assignments or to pursue non-complying employers. In fact, it cannot influence the use of income withholding in those cases where the assignment is mandated by law. The latter part of the rule reminds the attorney of his or her legitimate role in the formation of policy in the 4D agency, at least with respect to areas about which the attorney has knowledge. Just as attorneys are encouraged to advise private clients, the child support enforcement attorney should try to influence the behavior of the 4D. Rule 3.1 requires attorneys to refrain from bringing non-meritorious claims or asserting frivolous defenses. An exception exists for good faith attempts for an extension, modification, or reversal of existing law. Rule 3.2 requires an attorney to make reasonable efforts to expedite litigation, consistent with the interests of his or her client. Given their sizable caseloads, most child support enforcement attorneys need no reminder to expedite cases and avoid non-meritorious claims. The rule does highlight at least two collateral issues. However, the substantive law concerning child support obligations is often ripe for extension, modification, or reversal, and public policy is almost always consistent with any change which makes the enforcement of support obligations more effective. Rule 3.1 provides ethical support for such attempts. The other point raised by the rule involves intentional delay tactics and recognizes that delay may sometimes be consistent with the interests of one of the parties. In child support enforcement, especially with respect to paternity establishment, the obligator's attorney often will attempt to stall the proceedings. This tactic allows his or her client to avoid paying support in the short run. More importantly, however, the obligator has a chance of not being pursued at all if the case gets lost in the shuffle. The child support enforcement attorney has an ethical duty to recognize such tactics, point them out to the court, and skillfully employ local court rules and procedures to move cases through the legal system in a timely fashion. Impartiality and decorum of the tribunal. Rule 3.5 prohibits an attorney from, inter alia, attempting to influence or communicating ex parte with a judge, juror, prospective juror, or other official except as permitted by law. A child support enforcement attorney who deals with the same judge or judges on a constant basis will be tempted to discuss specific cases without providing notice to adverse parties. Such ex parte communications violate Rule 3.5, and should be avoided. It is just as important to note that discussions with the judiciary regarding the goals and problems of the child support enforcement program and the efficient processing of cases through the court do not violate this rule. Rule 3.8 applies specifically to a prosecutor in carrying out his or her official duties in criminal cases. The focus of child support enforcement has become decidedly civil since the advent of the 4D program. Thus, one could argue that the rule does not apply to the prosecutor or other attorney who conducts legal activity on behalf of a state or local support enforcement agency. While this may be technically true, the rule nevertheless recognizes the balance which must be struck between the attorney's duty to his or her client and the duty to act as an even-handed public official with substantial concern for the rights of adverse parties. The rule requires, inter alia, a prosecutor to make reasonable efforts to assure the accused has been advised of the right to, and the procedure for obtaining counsel, and has been given reasonable opportunity to obtain counsel. It also prohibits the attorney from attempting to obtain from an unrepresented accused a waiver of important pretrial rights. This issue came up in a different context in a 4D paternity case brought by the Ventura County, California, District Attorney's Office, in County of Ventura v. Castro, 93 calories. App. 3D 462, 156 calories. RPTR 66, dist.ct.app. 1979. An appellate court overturned a paternity acknowledgement because the unrepresented alleged father was not fully informed as to the ramifications of his waiver of right to request a jury trial and submit to paternity testing. This case is not cited here as evidence that the Ventura County procedures in effect at the time were lacking or unethical, but simply as evidence that some of the ethical considerations imposed on prosecutors in criminal cases may be relevant in child support enforcement cases. Truthfulness of statements to others. Rule 4.1 states that in the course of representing a client, a lawyer shall not knowingly, a. make a false statement of material fact or law to a third person, or fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless disclosure is prohibited by Rule 1.6. Unquestionably, subsection A of this rule applies with greater force to the attorney who represents a public agency than to a private attorney. No doubt, the scope of the definition of material is greater when applied to the government attorney, who has some affirmative duty to disclose information which is legally relevant to a pending legal action. See Chapter 4 for a more complete analysis of the relationship between ethical considerations and the negotiation of child support and paternity disputes. Communications with absent parents represented by counsel. Rule 4.2 prohibits an attorney from communicating with a represented party without first obtaining the consent of his or her attorney. This rule poses no difficulty for a child support enforcement attorney except where there is still an attorney of record from an earlier proceeding, such as a divorce. If the earlier proceeding occurred long ago, it can be difficult to determine whether the relationship still exists. The safest approach is to contact the attorney of record to determine whether he or she is still representing the parent. If the attorney denies the current representation, or if no attorney of record can be identified, all conversations with a parent should begin by asking if he or she has retained counsel. If the parent has obtained counsel, further communications regarding the case can be conducted through the attorney. Communications with unrepresented absent parents. Rule 4.3 requires an attorney to take reasonable steps to ensure that unrepresented persons understand the attorney's role in representing a client. The comment of the ABA Commission notes that unrepresented persons may assume that an attorney is disinterested in loyalties or that he or she is a disinterested authority on the law. If this is a common assumption with respect to private attorneys, it also must be a problem for government attorneys in their dealings with private citizens. While the assumption may be unreasonable or naive regarding the role of a private attorney, it is neither when applied to government attorneys, who are public officials and ministers of justice in addition to the other roles they fulfill. The child support enforcement attorney should fully explain his or her role to the unrepresented absent parent, and suggest that the person seek to obtain counsel if he or she does not understand the nature of the pending proceedings. Non-lawyer assistance. Rule 5.3 requires attorneys who employ or are associated with non-lawyers to make reasonable efforts to ensure that the non-lawyer's conduct is compatible with the professional obligations of the lawyer. This responsibility is applied more strictly where the attorney has direct supervisory authority over the non-lawyer. The lawyer is responsible for conduct of the non-lawyer that would be an ethical violation if engaged in by the lawyer, if the lawyer orders or ratifies the conduct involved. The lawyer is a partner in a law firm in which the non-lawyer is employed, or has direct supervisory authority over the person, and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. The Child Support Enforcement Program employs thousands of non-lawyers to prepare cases for litigation and to conduct pre-trial negotiation and collection attempts. In the collection field, the line between the practice of law and proper collection practices can be, at times, a hard line to draw. It is beyond the scope of this handbook to define the practice of law. The definition is determined by state law and judicial decisions, and affected by statutory language which clearly anticipates some activity by non-attorney child support enforcement personnel that would otherwise cross the line. For example, representing the agency in an administrative hearing, the child support enforcement attorney must monitor the activities of the non-attorneys with whom he or she works in light of applicable state legislation, case law, and tradition. Rule 8.3 states that assisting a person who is not a member of the bar in the performance of activity that constitutes the unauthorized practice of law is professional misconduct. This should not cause the child support enforcement attorney to fear delegations to program staff, and it certainly should not cause an attorney to be reluctant about training non-attorney staff regarding relevant legal knowledge. By carefully reviewing or monitoring all delegated functions and training non-attorney staff, the child support enforcement attorney can avoid ethical problems,